On June 27, 2024, just after 10:40 in the morning, the doors of London's High Court closed with unusual finality. Outside on the Strand, cameras waited for a statement that never came. Inside, a legal battle years in the making had ended not with applause or outrage, but with silence. Prince Harry stood, gathered his papers, and walked out without addressing anyone. What looked like a routine exit quickly took on deeper meaning for those paying attention. From the outside, the scene appeared controlled. No raised voices, no confrontation, but witnesses inside the courtroom later described a sharp shift in the room moments earlier. It happened during a pause less than 90 seconds long when the judge reviewed notes and asked a narrow procedural question. Not about harm, not about ethics, about timing. According to people familiar with the hearing, that question changed everything. For months, this case had been framed as a moral reckoning, a prince versus the press, a reckoning with old wrongs and long memory. Public filings emphasized emotional damage, betrayal, and years of personal strain. Yet in that room on that morning, none of that mattered. The focus turned to dates, calendars, and a 6-year window set by British law. When exactly did he know? When exactly did he act? And why now? Those close to the proceedings say the tension became visible. A tightening of posture. A glance exchanged between lawyers seated just 2 seats apart. No notes passed. No whispered strategy. Just a look that suggested the outcome was no longer in doubt. In legal terms, the issue was known as a time bar. Dry language, heavy consequences. This was not a judgment on whether harm occurred. It was a judgment on whether the court could still act. According to legal analysts, once that line is crossed, even strong claims can collapse. Evidence becomes irrelevant. Motive becomes secondary. The law simply stops listening. Outside the courtroom, the silence continued. No statement from Prince Harry, no clarification from his legal team. Requests for comment went unanswered. In cases like this, observers often expect immediate pushback or at least a controlled response. Here, there was nothing. That absence began to raise its own questions. Why had so much been placed on a case vulnerable to such a basic challenge? Why was this issue not resolved years earlier? And why did others, facing similar circumstances, reach very different outcomes? What happened next would turn a courtroom loss into something far more lasting. The ruling did not just end a case. It triggered consequences that extended well beyond that building, touching finances, reputation, and a growing comparison that Prince Harry has spent years trying to avoid. For much of his adult life, Prince Harry has framed his relationship with the British press as a defining conflict. Long before court filings and witness statements, there was a deep sense of grievance that shaped how he saw institutions, authority, and even his own family. According to people familiar with his thinking, the belief that he was wronged early and often became central to how he understood his public role. The roots of that conflict stretch back to the early 2000s when tabloid culture in the United Kingdom operated with few visible limits. Stories appeared with intimate details. Private conversations became headlines. For members of the royal family, intrusion was expected, but some intrusions crossed lines that later investigations would confirm. Phone hacking, surveillance, and unlawful information gathering were not theories. They were established facts in other cases, backed by police inquiries and settlements involving major publishers. Harry was not alone in being affected. Other public figures brought claims and reached settlements years ago. Some went to trial, others negotiated quietly. The key difference was timing. Many of those cases were resolved within the legal window. By contrast, Harry waited. Sources close to the palace say there were discussions, advice offered, and options presented well before any lawsuit was filed. But action was delayed. During that same period, Harry's public life was changing rapidly. Military service ended, relationships became serious, his role within the royal family shifted. By 2018, his marriage placed him at the center of intense media attention once again. That attention, according to those around him, reignited old anger rather than creating something new. Financial context also matters here. By the time legal action was seriously considered, Harry was no longer a working royal with institutional backing. He was funding his own battles. Advances from media deals and inheritance from his mother provided resources, but those resources were not unlimited. Legal experts note that high court litigation in London can drain millions before a verdict is ever reached. There were also warning signs. In early procedural hearings, judges signaled concern. About scope and timing, portions of claims were questioned. Deadlines became a recurring issue. Each time the case narrowed, yet the strategy did not change. Instead, filings leaned harder into moral arguments and institutional criticism. This was not the first time Harry had faced a choice between quiet resolution and public confrontation. Each time the same pattern appeared: escalation, public framing, emotional language. According to former advisors, that approach brought attention but rarely brought closure. By the time the case reached its final phase, the groundwork had already been laid. The calendar mattered more than the story. And once that became clear, the entire effort rested on a single claim that, if accepted, could reopen the door that time had closed. That claim centered on an alleged understanding said to have existed years earlier, one that Harry's team argued explained the long delay. According to his court filings, there was supposedly an agreement involving senior palace figures and newspaper executives, an arrangement designed to avoid public trials in exchange for future settlements. The implication was serious. If true, it would suggest coordinated restraint and deliberate silence at the highest levels. The problem was proof. When the court examined the claim, it found no signed document, no written confirmation, and no clear record that such an agreement had ever been communicated in binding terms. The argument relied almost entirely on recollection. According to people familiar with the ruling, that absence was decisive. Courts do not operate on implication alone, especially when deadlines are involved. What followed was methodical. The judge reviewed timelines in detail, noting when public information about hacking became available and when legal advice had been sought. Records indicated that Harry had consulted lawyers years earlier. He was not unaware, he was not blocked from acting. That distinction mattered. Once the time bar was enforced, most of the claims fell away at once. It did not require a ruling on morality or intent. The mechanism was procedural, but its effect was absolute. Legal analysts described it as one of the most unforgiving aspects of British civil law. This is where consequences began to multiply. Under UK rules, losing parties can be ordered to cover opposing legal costs. In preliminary stages alone, Harry had already faced five-figure cost orders. With the bulk of the case dismissed, those numbers could grow quickly. Estimates shared by legal professionals suggested exposure well into seven figures. At this stage, observers expected a response. A statement, a clarification, a pushback against what had just occurred. Instead, there was silence. His legal team declined to comment. Palace sources offered nothing. When high-profile figures lose controversial cases, immediate narrative control is usually a priority. Here, it was absent. That absence was noticed. Media coverage shifted tone. What had been framed as a crusade now looked like a miscalculation. And as attention widened, another detail surfaced in the court record that complicated the story further, one involving a quiet decision made years earlier by someone very close to the center of this conflict. That detail involved Prince William. Buried within filings and referenced almost in passing, it revealed that Harry's older brother had faced similar issues with the same publisher years earlier. According to court records, William chose a different route. Instead of litigation played out in public, he pursued a private settlement. The matter was resolved quietly, without testimony, without spectacle, and without reopening wounds that had already scarred the family. The timing was significant. William's settlement was reached in 2020. That date mattered because it sat well within the legal window. He acted while the clock still worked in his favor. Legal observers noted that this single decision insulated him from the very procedural trap that later caught Harry. The contrast could not have been sharper. Sources familiar with palace operations say William's approach was deliberate. The objective was not vindication in the public eye, it was closure. The settlement reportedly involved a substantial sum, though exact figures remain confidential. What mattered more was what followed. The issue ended. There were no lingering hearings, no escalating costs, no years-long drain of attention or resources. For Harry, this comparison landed painfully. His own filings referenced William's settlement as evidence that delayed action was normal. The court disagreed. The judge treated the two situations as separate choices made under the same legal framework. One met the deadline, one did not. This was not just a legal distinction, it became a reputational one. Commentators began framing the outcome as a lesson in strategy. Two brothers, same grievance, same access to advice, opposite results. The pattern was hard to ignore. Once again, there was no response, no effort to reframe the narrative, no acknowledgement of the contrast. In high-profile disputes, silence often invites interpretation. Analysts pointed out that when false comparisons are made, they are usually corrected quickly. Here, none came. By this point, the story had moved beyond phone hacking. It had become about judgment, timing, and the cost of escalation. The ruling closed one door, but it opened another. One focused on money, long-term damage, and a growing question about what happens next when legal avenues narrow and public patience wears thin. As the legal options narrowed, the financial reality began to surface with greater clarity. British civil law does not soften losses. Under the loser pays principle, defeat carries a price beyond disappointment. It carries invoices. According to legal analysts, complex high court litigation can generate costs at a rapid pace, especially when senior counsel and extended hearings are involved. By conservative estimates, exposure can reach millions. This was no longer theoretical. Previous rulings in the same case had already resulted in immediate cost orders. Tens of thousands were due within weeks. With most of the claims now dismissed, the scope widened. The publisher's legal teams had defended years of filings, motions, and hearings. Those costs did not disappear because the case ended early. They became collectible. People familiar with the process say this is where the emotional impact often deepens. Losing on substance can feel personal, losing on procedure feels pointless. There is no vindication to offset the expense, no symbolic victory, just a bill tied to choices already made. Observers also began to note secondary effects. Media partners grew quieter, appearances slowed. Projects once framed as principled took on a different tone when viewed through the lens of financial risk. According to industry sources, reputational uncertainty can be as damaging as legal loss, especially when it signals poor judgment rather than bad luck. Once again, there was no public acknowledgement, no plan outlined, no reassurance offered. For figures accustomed to controlling narrative, that absence stood out. Silence in this context did not calm speculation, it amplified it. What remained was an unresolved situation, a case closed without closure, money spent without outcome, and a growing sense among those watching closely that the consequences were no longer confined to one courtroom on the Strand. They were beginning to follow him elsewhere into decisions still unfolding. As attention shifted away from the courtroom, the broader implications became harder to avoid. Legal defeat has a way of narrowing future choices. Once a case collapses on procedural grounds, reopening similar claims becomes nearly impossible. According to legal professionals, courts rarely grant second chances when deadlines have been missed so clearly. That reality alone reshaped the landscape. There were also personal consequences. Those close to the situation describe a period of withdrawal, travel slowed, public appearances became more selective. The absence of a clear next step created uncertainty not just externally but internally as well. When a long-running battle ends abruptly, the vacuum it leaves can be destabilizing. Institutional responses were subtle but noticeable. Media coverage became less sympathetic. Analysts began referring to the case as a cautionary example rather than a moral stand. Discussions turned to risk assessment, legal strategy, and the dangers of treating litigation as symbolic action. The tone had shifted. Still, unanswered questions remained. Why press forward despite repeated warnings? Why rely so heavily on an unproven agreement? Why escalate rather than resolve when quieter options existed? These questions did not require speculation. They emerged naturally from the timeline. Insiders say what happens next matters more than what already occurred. Further appeals would be costly and uncertain. Walking away would require acceptance of a result that offered no emotional satisfaction. Neither option is easy. Both carry consequences. For now, there has been no definitive statement outlining a path forward. No explanation addressing the core issues raised by the ruling. No acknowledgement of the comparison that continues to follow him. In high-profile disputes, unresolved silence can be the loudest outcome of all. The courtroom doors may have closed, but the story has not reached resolution. Those watching closely understand that this moment marks a turning point. Not because a judge spoke, but because the options ahead have narrowed, and every move from here will be measured against the choices that led to this point. What remains now is a question of direction rather than judgment. The legal system has delivered its answer, but it did not deliver meaning. That part is left unresolved, according to people. Familiar with the aftermath, the ruling forced a private reckoning that no public statement could address. When a battle framed as a crusade ends on a technicality, it leaves behind more doubt than closure. There is also the matter of pattern. This was not an isolated decision made in a vacuum. It followed a series of choices that favored confrontation over containment, exposure over resolution, and symbolism over outcome. Observers who track high-profile litigation note that this pattern tends to repeat until a cost becomes undeniable. In this case, that cost arrived in the form of time, money, and narrowed credibility. Silence continues to define the aftermath. No denial has been issued addressing the court's core findings. No counter-narrative has emerged explaining the delay in action. When public figures believe a ruling is fundamentally flawed, responses are usually swift, appeals are announced, arguments are reframed. Here, there has been none of that. The absence remains notable. Those watching closely say the next phase will not be decided in a courtroom. It will be decided in restraint or the lack of it. Escalation remains possible, but it would come with steeper risk and diminishing returns. Withdrawal would protect resources, but at the cost of accepting an ending that offers no validation. Each path carries weight. In the end, the image that lingers is not of a verdict being read, but of a quiet exit. A moment where expectation met procedure and lost. The doors closed, the cameras waited, and a legal gamble years in the making ended without the acknowledgement it sought. This story continues, not because more evidence is coming, but because its consequences are still unfolding. Those familiar with power, timing, and institutions understand one thing clearly. When the law stops listening, what follows is never just about the law.